I've just noticed that Ms. Gale, is it? I haven't got any video connection at the moment. I
don't think she's taking part. She's not going to be speaking.
All right. Okay. Thanks very much. So if anyone's having difficulty seeing or hearing any participant, would you please let me know just by raising your hand. Can I check that everyone, could you raise your hand to make sure I'm sure that you can hear me at the moment? Yes. Fine, thanks very much. So my name is Malcolm Marnie, and I'm the inquiry reporter appointed by the Scottish Ministers to determine the appeal by Edinburgh Marina Holdings Limited against the failure of City of Edinburgh Council to determine detailed planning application reference 20-05731-FUL. And the application is for the formation of access roads, cycleways and public realm areas around plot 35A at Granton Harbour in Edinburgh. So I'd like to confirm those who are taking part in this hearing session. Could we start by having the council team introducing themselves, please? And that'll perhaps double as a sound check. You may need to unmute yourselves first. So if we could just start with the council, please.
Thank you, sir. Good morning, everyone. My name is Lottie Flood. I'm a solicitor in the council's in-house team, representing the council this morning. And also representing the council are Chris Sillick, who's planning officer and the case officer for the application, and Leslie Carris, who is one of the council's planning managers with responsibility for the Edinburgh waterfront area. I'll let Chris just introduce himself as well, just to check his sound, just to make sure he's there.
Yeah, so as Lottie said, my name is Chris Sillick, so I'm a planning officer with Edinburgh Council, working in the waterfront team, and I was the planning officer responsible for this application.
And I'm Leslie Carris, and I am the team manager of the waterfront area team.
Okay, thank you very much. And could we have the same, please, now for the appellants team?
Good morning, sir. My name is Maurice O'Carroll. I am counsel for the appellant. I've been instructed by Messrs. Turk and Connell, and we have a representative from that firm with us today, Alexandra Gell, to whom you've already made reference. I'm also joined by Mr. John Payton, who is the planning consultant involved with this particular project and has been for quite some time, and also Mr. Charles Price from the appellants.
Thank you. Now I have Mr. McGavin also mentioned. Is Mr. McGavin participating this morning?
I will just be here mainly in an observation capacity, but will be supporting the client if required.
Okay, thank you very much. Okay, so first some housekeeping points. This is a virtual hearing and it's being streamed to allow interested parties to watch and hear the proceedings online. Would you remember, please, to turn off your mobile phones now? They're on. Now the arrangements, virtual procedures can be quite demanding on participants, so we'll be taking breaks at suitable points in the proceedings. If we need to continue into the afternoon, we'll take a lunch break starting from around 12:30 or 1 o'clock. I would expect to finish by mid-afternoon at the latest. And when you're not speaking, would you please mute, just so we can make sure we cut out any unnecessary background noises. And when you wish to speak, would you please just raise your hand as you have been doing and unmute yourself. During the breaks, would you mute and stop your video so that main confidentiality. We don't use screen sharing in virtual hearing sessions, so would you please just refer to documents and we will each consult our own copies. Okay, so I'll then move on to explain the procedure this morning. The default procedure for appeals is by written submissions. In this appeal, many of the arguments and points, including all of those made by third parties, have given me sufficiently clear picture for my purposes. But having read all the submissions and documentation and made an unaccompanied visit to the site and surroundings back in July, I considered that further information was required in relation to 7 matters. Therefore, issued a procedure notice on the 19th of August, setting out those 7 matters and inviting comment from the appellant and the council. These all relate to issues raised by the appellant and the council and not by other parties. The appellant and the council have responded to those 7 matters, but I remain uncertain about aspects of those responses. So I've called this oral session to clarify those aspects. So the purpose of the hearing is for me to understand more about those matters so that I have enough information to determine the appeal. So to do that, I'll read out each matter in turn, and then for each, I'll read out those sections of the responses from the council and from the appellant on which I require more clarity. I'll then ask questions of the side who wrote each response, followed by an invitation for the other side to comment. And I'll make sure that both sides have plenty of opportunity to have their say on each matter. Please note, we'll only be discussing those 7 matters and only the planning issues and not the behaviour of parties, for example. When we've gone through all of those 7 matters, each side will have an opportunity for a brief summing up, and I'll ask you not to introduce any new points at that stage. You'll know that, I think, or some people will know that following the receipt of responses to my procedure notice, the legal advisors acting for Edinburgh Marina Holdings requested a 3-month cyst on this appeal. I have not agreed to that cyst. I would point out, however, that I do have the option of requesting further exchanges in writing if I consider that's necessary. Now, I'll be taking notes as we go, so I may need to ask speakers to slow down from time to time if I'm unable to keep up. So, does anyone have any questions about the procedures? That's great. Now, I've got one preliminary matter, which is that just a few days ago, I asked the council if they could supply a copy of a drawing, which was the red line outline drawing for the original outline planning permission dating back to 2003. And I've had an email this morning from Mr. Sillick, and I'll just read it. Due to the age of the application in question, I do not have the requested plan available electronically. I also do not have access to the original paper file at this time and will be unable to provide this in advance of the hearing tomorrow. This may or may not be anything that we need to follow up. It depends how the discussion goes. But what I suggest is that if it does become something of significance, then I'll ask Mr. Sillick if he can submit a copy of that drawing later, and then we could have a written exchange if need be about anything that arises from that. Okay, so now I'd like to move on directly to the discussion of the matters numbers 1 to 7. So, can I ask you to have in front of you the appellant's response to my procedure notice dated 31st of August, That's the appellant's response dated that, and the council's response, which was dated 2nd of September. Okay, I'll start by reading matter 1, which as it appeared in my procedure notice. The appellant has submitted an application in detail for the formation of roads, cycleways, footways and public realm, part of which extends over derelict and uneven land and land covered by seawater. However, the application does not include works for filling and levelling the ground, constructing a new harbour wall and constructing a revetment along that new harbour edge, all to support the proposed scheme. The report notes that a recent similar application for plots 29 and 35 by a different developer did include such details. See appeal reference PPA-230-2340. The current application therefore appears to be incomplete and incapable of realisation in its present form. Can it be consented in this form? So, if we now look at the appellant's response on this matter, my first question of the appellant relates to paragraph 1.7. So paragraph 1.7, I'll read it all the way through. It was intended that details of the groundworks and harbour edge would form part of an application for the development of the 2 residential plots that lie within the present appeal application, known as plot 35A. As a portion of the application lies out with the boundary, this will be an application for full planning permission, and due to its site area and housing capacity, it will fall within the major development category of the Town and Country Planning Hierarchy of Development Scotland Regulations 2009. Accordingly, pre-application discussion took place from 17th of June to 7th of July 2021 in advance of submission of this application. This application will complete all approvals necessary for the construction of this part of the approved Granton Harbour master plan. So my question on this is, isn't this order of applications with the current application followed by the one just described, the wrong way round? Because neither application can proceed until the groundworks and harbour edge are approved. So seeking approval for roads, paths and public realm in advance of the groundworks and harbour edge seems to be premature. It implies that consent will be forthcoming for those works, but we must remember that there is no planning permission in principle for development on a significant part of the land in question. I should say that none of my questions today will reflect a fixed point of view. I'm open to hear other viewpoints. So who from the appellant's team will reply to that, please? I'm sorry, I can't hear.
Sorry.
Yeah.
Schoolboy error. That's my first one. Hopefully that's my only one. I will respond first, based on instructions, having consulted with my clients in this matter, and I'll ask Mr. Payton to add anything I might have omitted. As I understand it, and certainly looking at the council's response to this, which you haven't read out, but we're all aware of, my submission today is that what is lacking in the appreciation for this application that is before you, and let's not forget that it's a fairly minor application in relation to a very large scheme, and the scheme itself is in fragments, and certain parts of those fragments are more advanced than others. This application is merely for roads and the public realm, as you've outlined and as is clear from the council decision of 17th of March of this year. What is lacking from consideration of this in my submission is the master plan. We have a master plan going back to 2003, but we have an updated master plan which was approved by the local authority on the 26th of April having been lodged some 4.5 years prior to that date, and that is version 27D. There is an up-to-date version of that, which is called Z7D. There's an up-to-date version of that, which is Z7F, which was produced in order to assist the councillors in relation to the present application, so that they could see which parts of the overall scheme had been consented and which parts remain to be consented, and therefore a tool for them to assist in their decision making. The matter remains that the substance of that is as approved by the council on the 26th of April of this year. Further to application 170284 AMC, and I say the version of that master plan is known as version Z7D. If you would like to turn to the master plan, which I have in front of me, and I'm looking at the version Z7F. Do you have that, sir?
Yes, that's fine, thank you.
You can see from that the annotations have been supplied in addition to the approved application 0284 AMC, as I say, for the benefit of the councillors. And you'll see that at the part where plot 35A is marked, you'll see the annotation there, line of rock revetment as per master plan approval 06036336 REM for revetment and housing on reclaimed land, approved on 4th of March 2009, C drawing AP00G7007. So the position is that this has been approved in outline by virtue of the master plan having been approved in April of this year. And indeed, the April decision makes cross-references the decision of the 17th of March of this year in relation to this application, where the council apparently approved the scheme which is now before you. So there's not a question of prematurity, because the groundwork and the permission in principle has already been established. This is an application for the limited amount of works for the roads and public realm, as is clear from the heading to the 17th of March decision: formation of access roads, cycleways and public realm areas around Granton Harbour, plot 35, sir, plot 35, not 35A, and this distinction is important. But that is what the application is, and the groundwork has been set for it for the reasons I've just said. So it's not premature, and it can be granted in this form, in the short answer to the simple question you've asked. Now that's the matter as I understand it, and I would like to ask Mr. Payton to answer the question in his own words, if he feels there's anything that might differ from what I've just said.
I think the important part to remember here is that we are presenting, or the application was intended to present the council with a comprehensive scheme. Now, when the application was submitted, there was the development of the hotel was in its formative stages. My client was was involved in discussions with investors and developers, and indeed is still in that process. And it was necessary to get the road layout around the hotel approved as quickly as possible. Now, by that time, the master plan had already been submitted that showed the roads round plot 35A, and it seemed it would have been rather strange to submit an application which omitted the full road network and only showed the roads immediately around the hotel, which we all then knew would be extended to cover the roads round plot 35A as well. So in the interest of presenting a comprehensive position regarding roads and public amenity areas, the application was submitted to include these areas. rather than in what would have been a rather incoherent part drawing or part application, which would have left questions over parts of the network which weren't within the application boundary. So the approach was intended to be comprehensive. It was a comprehensive network rather than a fragment of the network necessary for the hotel.
Okay, thank you very much. Would the council like to comment on that response?
Yes, sir. Thank you. Thank you for that. I would start by saying that you'll be aware from our wider response to the appeal that our position on the master plan is not the same as what the appellant is setting out, and indeed we don't consider that any of that is especially relevant to the application before us today. And I'll allow Mr. Sillick to come in and comment further if he wishes, but in our view, what's before you today is a full application with the detail in it. That's what was assessed by us. That's what was recommended for approval to the Development Management Subcommittee, and that's the basis on which we're here today. So I wouldn't intend to say much more about that. I'll ask Chris to come in if he wants to say a little bit more on the detail, but that would be our position just as a very starting point before we start getting into all that extra detail, if you will.
Yeah, thanks, Lottie. I suppose I won't go into too much detail here. As Lottie's alluded to, we've expressed further on in our response to the procedure note that we don't feel that the master plans in themselves give planning consent. That they're exactly that, they're master plans. They don't address the reserved matters outlined in the outline planning permission. But in particular to the master plan that was referenced there by council, 1702-484 AMC, there's specifically a condition within that which says that the reserved matters covering siting and height development, design and configuration of public and open spaces, access roads, layouts, footpaths and cycle routes are not approved in respect of 35A. So I would suggest that any suggestion that the master plan that was consented in 2020 gives consent for the land would be incorrect. Also, if we go back to the 2009 master plan, 0603636 REM, then again, the matter of the infill of land and the specific details of the rock revetment wall weren't provided at that time, and there's a specific condition within that master plan which addresses that matter, requiring in particular information relating to the rock revetment to be provided. So again, I would suggest that that doesn't provide planning permission for the land. These master plans are indicative and they're useful for giving us information on the siting and the uses that are present, that are expected at Granton Harbour. But beyond that, they don't give planning permission. Thank you.
Okay, thank you. Does the appellant wish to come back on any of that?
Yes, sir. I'm looking at the council's response to this, and I must confess, as I'm sure my clients are, to being a little bit confused as to the council's approach. We have had a brief acknowledgement of the fact that on the 17th of March of this year, this application was granted. It was granted because it was in accordance with the relevant part of the development plan, and with consultation with the council's transport division, it was found to be acceptable. But we now seem to have a position at divergence from that, which seems to be which is a divergence of that, and so we have a fairly confusing position. If I look to the response by the local authority at the end of matter one and their response, and it says the council acknowledges that the proposed layout of roads, cycle paths and public realm can only be achieved if a subsequent application for planning permission is made in relation to the repositioning of the harbour wall and the infill part of the site. The council acknowledges that the issue of the position of the harbour wall and the infill land is fundamental to the delivery of this layout, and would not oppose a decision by the reporter to uphold the deemed refusal of this application on this basis. Now, there's slightly confusing wording of that, because when, as a lawyer, we're talking about upholding anything, then you're usually talking about upholding an appeal. So on one blush, it would appear that the council agrees that this appeal should be granted. But in light of the words that go before that in the earlier paragraphs, it appears to be that what the council is saying, that yes, we've granted permission for this proposal as stated with certain indicatives, and we won't get into that, but that by virtue of passive failure, a failure to go ahead and issue the planning permission following upon the decision which it in fact made, it now seems to be saying, as far as I can tell, that they have made an error and that they shouldn't have granted the planning permission, which they did grant on the 17th of March, or rather the decision shouldn't have been made as it was on the 17th of March. And now the council is taking the opportunity of this particular appeal and these questions before you, sir, to undo that mistake without the consequences of compensation that might otherwise follow from withdrawal of a planning permission being granted. And that is a baffling approach to take in relation to this. So it cannot be that the council's position is that they have insufficient information, because they said on the 17th of March that they did have sufficient information and they did have the sufficient wherewithal and details before it to grant that permission, subject to various indicatives which involved sums of money being paid and so on. So their own position now today is difficult to understand. And the reason why the appellants are baffled, and the reason why they say this permission should have been granted, rather the permission should have been issued following that decision, and that it can be granted and is not incoherent, is because in good faith they provided the fullest details as requested by the local authority itself further to this matter before dealing with far more substantive and important parts of the overall fragments of the master plan. So it's not accepted that it is premature, and it's not accepted that it is incomplete, as indeed the local authority has itself acknowledged in March of this year. Mr. Payton, I don't know if Mr. Payton has anything further to add.
No, I don't really have anything to add. I think I would emphasise that the approach for applications for the roads and public realm around the housing plots in Granton was agreed previously with the council. This was an approach whereby the roads and the public realm areas would be the subject of, you could almost describe it as a layer of approval. The previous sites were the subject of similar applications in the past, and indeed some of these sites covered areas that were out with the original outline planning permission boundary as well. That they were viewed as establishing a layer of approval within the site. And again, in this case, it was decided, or it was thought reasonable, to include the entire network in that area to present a coordinated and complete picture of the roads and public realm in that area.
Okay, thank you. I've noted these points. I don't want of course, this matter now lies with me rather than the council, so I don't want us to go particularly far into as I said earlier, the council's behaviour on this. So I'd like to move on then. And the next paragraph, 1.8,
Sir, would you mind if we were able to just provide a couple of comments in response to what the appellants have said, just to round off that matter?
Okay, yes.
Yeah, I think it's important for us just to emphasise that the council's position has not changed, has not, you know, deviated or differed from the position that was set out in the report of handling, which went to the committee in March. The recommendation was for approval. That was obviously taken forward by the committee. They were happy to approve the application. We have no problem with the way the application was presented. We're entirely satisfied with the principle of development as set out in the application. You know, I think that's clear from the fact that it was approved. The responses that we have provided in response to your procedure notice were really in response to the questions you had raised about whether or not the application or the permission could be issued as it is, and we're entirely satisfied that it can be, subject to the conditions that we had attached to it in terms of the report of handling, and which was ultimately approved by the elected members. So I think I just wanted to emphasise to you and to others that there hasn't been a reversal of the council's position. It remains as set out in the report of handling and as set out in our response to the appeal earlier in this process. So I hope that's helpful, but that's really all I wanted to say on that matter.
Okay, thank you. We turn to 1.8 of the response. It reads, the current appeal application was therefore prepared and submitted in accordance with the previous council requests that roads and public realm applications be submitted to accord with the development layout approved in the master plans and effectively as overlays, providing greater detail than shown in the master plan. My concern here is that the current site is different from most sites at Granton Harbour in that it extends partly out with the area covered by the planning permission in principle and partly onto land which requires groundworks and a new harbour edge prior to development. And my question there is, doesn't that require a different approach? So again, Mr. O'Carroll.
Doesn't that require a different approach? I'm not sure I can really go assist any further with that. Mr. Payton has provided you with an answer as to the approach taken and the reasons for it and the background to it. What I can say is that the council is also well aware that there is about to be submitted a detailed application in relation to plot 35A. And the reasons why plot 35A application is detailed is because it is acknowledged that it goes beyond that red line. And that is expected to be submitted on the 12th of November. The reason why the council is well aware of the details of that application is because due to its size, it was the subject of public consultation, which has only been concluded in July of this year. So in terms of all the fragments coming together, the other fragment that is important and addresses the point you've just raised with regard to the red line is acknowledged, but that is to come in relation to plot 35A and the detailed planning permission, which is to follow from that.
Okay, thank you. Does the council wish to make any response to that?
Thank you, sir. I think we are aware of those details of those applications coming forward, and you know, I don't think there's any issue with that at all. I think we're quite ready to receive them and determine them as you would ordinarily expect. Chris, I don't know if there's anything you want to add to that.
No.
Okay, fine, thank you very much. If we move on to 1.9, reads, in answering the reporter's question, the present application represents a specific roads approval in the knowledge that certain parts of the site will in effect be suspensive until further details are approved. So if I just pause there, if I were to allow the application as the appellant wishes, and let's say the land changed hands, would there not be potential confusion as to whether the works could be undertaken without further permission for groundworks, because there would be seemingly no indication in the decision to say so. Mr. O'Carroll.
Just a moment, please. Thank you. I was just adjusting my set, to use an old phrase. Let me just find that paragraph. So you're referring to paragraph 1.9.
Yes.
And these are the words of Mr. Payton. He might be best able to answer that specific question, but if I could just ensure that I understand it, sir. That if you were to allow the planning permission, but just hypothetically, the site were to change hands in the meantime, then I think your point would be that if it were to be changed meantime, then it would no longer be implemented, be capable of implementation by the new owner.
No, I was saying, would there not be potential confusion as to whether the works could be undertaken without further permission for groundworks, because there would be no indication in the decision to say so?
Mr. Payton.
I'd imagine that anybody acquiring a piece of land with the benefit of planning permission would, due diligence would require them to establish what permissions existed, and would have to analyse the position, just as we have to be mindful of the position we're in now, and hopefully with planning permissions in place. There will always be a situation where somebody acquiring land has to analyse the planning permissions that exist at that time, and would need to ascertain what additional permissions they were required to obtain for whatever work they were proposing to do. And I suppose it would be the same with the buildings in Granton Harbour. A buyer of a site would have to ascertain what permissions are there, what permissions remain to be sought, or what alterations would be required.
Okay, thank you. Ms. Blood, any response to that?
Not especially, sir. I think that's really just what we wanted to emphasise in terms of having those conditions 5 and 6. That's what gives you the clarity as to what hasn't been consented in terms of the application before us. And in a sense, having those conditions makes that process, much simpler in terms of knowing what you have to come back with at a later date.
Okay. Fine. Okay, and I'll move on then in that same paragraph 1.9. It reads, the council has requested, registered and approved similar applications for Granton Harbour previously, and the present application was registered, presented to the subcommittee and minded to be approved without any request for rock revetment details. Mm-hmm. So my question there is the applicant saying, the appellant rather, saying that there is no need for rock revetment to be constructed, or that it intends to construct a rock revetment based on what it says is permission under the marine license? Mr. O'Carroll.
Yes, sir, exactly the latter of what you just said. It is the marine license that will cover the rock revetment. And as the council acknowledged, the application itself, 2005-731 full, was complete in itself and was capable of being granted, as indeed it purported to do in March of this year. The revetment detail will be massive for Marine Scotland. Mr. Payton.
I wouldn't add anything to that.
Thank you.
Okay, and Ms. Flood?
I think as we've set out, the fact that there's a marine licence in place doesn't negate the need for the planning process to also be followed, and the application would need to come forward with the additional details for that. And I think that's been set out. Chris, do you want to say anything further on that?
No, I agree with what you've just said. the marine license doesn't negate the need for planning permission. This would be development. Unless it's permitted development, then it needs planning permission.
Yeah.
Okay,
So-
thank you. Right, I'll move on then to the council's responses on the same matter, if I could. So the first paragraph of the council's response, oh, sorry, I don't have questions on that. It's the second paragraph of the council's response, which reads, the council recommended the approval of the proposed layout of roads, cycle paths and public realm, as enough information was provided in relation to those matters. The applicant provided no information in relation to the rock revetment or the residential units. Therefore, no determination could be made on the acceptability of these matters. The proposal is therefore only acceptable if it relates to the proposed layout only. A future application for planning permission will be required in relation to the repositioning of the harbour wall. So the question there is, by proposing to allow this application, you're implying that the repositioning of the harbour wall would be approved subsequently, and I'm questioning whether that can be assumed, because the council's proposed decision would fetter the discretion of a future council committee meeting in its decision making, for example, if new evidence of some type came to light. So, Ms. Flood.
Thank you, sir. I don't think it's the council's intention in that sense to have tried to fetter its discretion as to future applications, but nor do I think there's any real dispute about the need for the harbour wall or the development that would take place surrounding it. I think that's been set out, it's been discussed over a number of years, so I don't think there was anything in the council's response which suggested that an application would be determined one way or the other. As you say, any application being brought forward would be considered on the information available, the details submitted, and the merits of those, as determined by the planning judgment of the officers or the elected members. Chris, I don't know if you want to add anything.
No, I have nothing else to add on that.
Okay, Mr. O'Carroll.
Yes, sir. I'd like to comment that the first sentence in that paragraph really says it all. Council recommended the approval of the proposed layout of roads, cycle paths and public realms. Enough information was provided in relation to these matters. Question really arises, why wasn't the end of the matter, and why wasn't permission therefore issued? I would then suggest that when we go on to look at the next sentence, the appellant provided no information in relation to the rock revetment or the residential units. The simple answer to that question, that statement, is that there was no information provided in relation to rock revetment because none was requested by the local authority. And none was requested by the local authority because it wasn't relevant to the particular permission that was being sought that we're now dealing with.
Okay.
And incidentally, of course, I do obviously accept that a marine license is not a substitute for planning permission, and that's something that will become clear later on in this discussion. That's not what is being suggested. But in terms of the actual technical aspects of the revetment walls will be a matter for Marine Scotland to regulate using that particular jurisdiction. But it's not being suggested that it takes the place of planning permission, but planning permission which is being sought here and will be sought in relation to plot 35A. And let's not forget that this particular application is in relation to plot 35, which is next door.
Flood, anything to say in response to that?
No, I mean, as I've said before, the position with the council was we're happy to approve the application subject to the conditions which clarify, which aspects of what is shown on the drawing and on the plan are not part of the consent. And that was why we said we don't have the details, for the rock revetment, for example, and therefore that does not form part of the consent. I don't think there's any dispute about whether it was meant to or whether, we have or haven't determined that. That was simply a clarification on our part to show that, notwithstanding the fact that it is shown on the plan, we don't have the details and it doesn't form part of the permission that would be in front of us. Chris, do you want to say a bit more in the detail?
I think that covers a lot there. We've obviously clarified the terms of the consent, in that we haven't assessed the land, we haven't assessed the rock revetment. That it's been stated there that we didn't ask for any details in relation to the rock revetment. Now, when I initially picked up this application and identified the fact that the roads were on land that didn't exist yet, I contacted Mr. Payton and suggested that a good starting place in that process might be for him to provide an updated drawing showing all the new land that was to be provided, as in to colour it, so that we could define what the new land was and what the existing land was. And I believe Mr. Payton's response at that time was that he didn't believe that they needed planning permission for that land. And we got into a debate about obviously the master plans and what status they have, at which point we've obviously decided to go down the route of consenting the elements of the scheme that we were comfortable with, and that we definitely have enough information to determine, that being the layout of roads, the layout of the cycle paths and the public realm. And indeed, the description for the application states that that is the only thing that's been applied for. It doesn't mention a rock revetment, it doesn't mention the infill of land.
Yeah.
We've never been provided with any information that we could use to determine these elements. So we've therefore included conditions 5 and 6, which define the terms of the consent.
Thank you. Mr. O'Connell, anything you need to come back on that?
Mr. Payton, I think you were referenced directly there. Is there anything you wish to come back on?
I think the email that Mr. Sillick's referring to actually contained a request for a whole range of information, which was actually provided. I don't recollect terms of the email being so specific about the rock revetment. And our position was that the rock revetment was not part of this application. It was an application for roads in public realm areas. It wasn't, I have no recollection of a statement that it was actually not required. We did actually provide you with a lot of supporting information, and if I remember rightly, it was all relating to transport works and the alterations to the road network. We've never actually, I have no recollection of saying that was not required. The application was not required.
Thank you, sir. Nothing further to add.
Okay, thanks very much. Okay, that's the end of my questions regarding matter 1. We can, yes, I think if we're happy to move on, we'll take the matter 2 and then take a break after that, I think, short break. So matter 2, as set out in the procedure notice, is that the appellant contends that the proposed condition 6 regarding repositioning of the harbour wall is unnecessary, as this has already been approved in detail as part of a marine licence. No material in support of that contention has been submitted, and the reporter is not aware that a marine licence would overcome the need for appropriate permission under planning legislation. So appellant's response, I'll just read the 2 paragraphs. The marine licence for the Inner Harbour Works is reference 06806/19/0, approved on 5th of April 2019. As discussed in the previous matter, the public consultation for the adjoining site designated Plot 35A has now taken place, and the application of the development of this site and the harbour wall will shortly be submitted. That application will contain details of the revised position of the Inner Harbour Wall, brackets rock revetment, in accordance with the 2009 approval and the most recent master plan approval, revision Z7D. So I'd like some clarification on what the appellant is saying here. Does this mean that the appellant no longer wishes to rely on the marine licence to support construction of the repositioned harbour wall and rock revetment, or infill of the land behind it? Strickland.
Yes, so I think the response is stating in terms that the marine license is one thing, but the planning permission is another. And the planning permission is in relation to plot 35A. And as I stated earlier, the plot 35A is a detailed planning permission, which will deal specifically with these matters. But doesn't form part of the current application, obviously.
So you're saying that that application will include details of the revised position of the harbour wall and rock revetment. Is that do I
That's
understand?
my understanding. Mr. Payton could please confirm that.
Yes. Yes. It was made very clear in the public consultation that the application boundary would include the rock revetment wall and all other matters regarding the infilling of the land.
Okay, fine. Spud, any comment on that, please?
No, sir, we don't have any disagreement with that position at all. Planning permission sits alongside the marine licence, and we understand that, you know, the applications are to be made in due course.
Fine. Okay, thank you. And I have no questions regarding the council's response. Fine. So, anyone want to raise any other matters there before we take a short break? Okay, fine. So let's just, is 10 minutes enough? Just for yeah, so it's 5 to 11 now. We'll resume at 5 past 11. Thank you. I suggest you turn off your videos and mute. Right, thank you. It's now 11:05. We can resume. So if we could just pick up then on matter 3, and I'll just read that out. Starting from 2009 and through to April 2021, there have been several master plans for the approval of matters specified in Condition 2 of Outline Permission 01/00802/OUT. Which of these are valid and on what basis and to what extent? So the council's response here was in its its first paragraph, says the current approved master plan for the site is set out in application 17/02484/AMC. This supersedes previous master plans covering the site. But I'd like to know on what grounds. So if we look at the permission 06/03636/REM, that gives 15, condition 2 gives 15 years from the date of outline planning permission for commencement. And there are other conditions referring to various different time limits. So, so the question is, on what grounds does the council say that this supersedes previous master plans covering the site? Ms. Flood.
Thank you, sir. I'll ask Chris to come in on that first, if that's okay.
Yeah.
So our understanding on this matter, on the matter of the master plans, is there's nothing in particular within them that could be developed in terms of initiating development. So we were unsure really that you could go between a master plan that was granted 12 years ago, replace that with different iterations of proposed development for the site, and then decide further down the line that actually, even though you've applied for consent for several different master plans over the years, that you want to revert back to the previous master plans as required. So applications have been made to change these master plans. They've been considered at committee, they've been consented in various different forms. So we're unclear how you could go back to previous versions of the master plan. Our position is that once the master plans, a proposal has been received to update these master plans, then it supersedes the one that went before it.
Okay, thank you. I'll run down the rest of that response and then and ask another question, and then come back to the appellant at that point, I think, to deal with both of those points. So the council's response goes on. The council notes that there is no requirement for a master plan set out in the original outline planning permission or in the subsequent extension set out in application 18/01428 PPP granted through appeal PPA-230-2340. The master plan is useful in establishing proposed uses within each plot, ensuring these uses are consistent with the outline planning permission. It's also useful in giving information on the siting of these uses. However, provision of a number of master plans over the years does not address the conditions set out in the original outline planning permission. Future development of the site within the red line boundary of the outline planning permission extended by application 18/01428 PPP will require an application which addresses the conditions of the outline permission. The council note that the red line outlined in 18/01428 PPP differs from the original red line of the outline permission granted in 01/00802/OUT. That's the point at which I thought I would ask for a copy of that red line drawing, and we hear that's not available. But my question in relation to that was, how can this be, since the application 18-01428 PPP was simply to extend the time period of the consent? I can't see how that red line could change in that case. So, Ms. Flood.
Thank you, sir. I'll ask Chris to respond on that to the extent that we can, and perhaps Leslie may be able to give some of the background as well, but I'll hand over to Chris in the first instance.
So on this, yeah, because obviously a lot of this discussion, around this application is centered on what has planning permission and what doesn't. As part of my assessment process for the application itself, I went back through a significant proportion of the planning history for the site. And within that, there was one particular application in the past. It's not before you, and to be honest, I don't think it affects this application. It's for a different part of the site altogether, but for the sake of openness and explaining that response, I can provide you with the application number. So it's for an application in 2004, 04/00191/RAM. And within that, I found this related to the partial infill of the key in plot 7. This was dealt with as a reserved matters application, but actually this part of that site actually falls out with the red line that is shown in the 18 planning permission in principle. So my position at the time was that the only way it could have been dealt with as a reserved matters application was if the red line had changed. Now, my position on that now is that obviously this could have been an error from the applicant at the time in providing the wrong site plan, and an error from the council in addressing this as a reserved matters application, and not that the red line itself has changed. That's potentially an error in my statement. But we're content that this doesn't affect this application. It's for a different part of the site altogether. We're content with the red line shown in 18/01428/PPP. We have no concerns about that red line at all. It was granted on appeal. We have no intention of querying that.
Okay, that's helpful. Thank you. Okay, Mr. O'Carroll, the two questions. Then the first one to do with the whether master plans have been superseded, and comment. Well, I don't know if any comment is needed, but if you wish to, then on the red line as well. Thank you.
Yes, I think the matters. I think we're in agreement with the council here that the benefit of the master plan contained within application 02484 AMC Z7D is the up-to-date one. That's the useful one upon which we go, and indeed the one in which the councillors were advised recently in relation to this application before us. In relation to the red line of...
Sorry, just before you move on, so you're agreeing that this previous master plans are superseded by the new one? Is that the position?
Mr. Payton, that is my understanding. If you could confirm or...
Yes.
Yes.
There was no intention that any previous master plans still have any currency. The master plan that we're working on is the current one that was approved in April this year.
Yeah.
Maybe I could also just add that earlier on in the council's response paragraph, it seems to diminish the importance of the master plans, but I would emphasise that they are submitted as AMC applications discharging condition 2 of the outline planning permission, and therefore I feel that they have more substance and weight to them than was suggested or is suggested in the council's response to this matter, that they do discharge a condition on the outline planning permission.
Yeah, thank you.
Okay. So if we move then on to the appellant's point here, let me just see. No, that's okay, fine. Mr. Payton's answered the question I had here. That's fine, thanks very much. So if we could then move on to matter 4. The appellant wishes to rely on Planning Permission 06 Bleak 03636 REM granted in 2009 to discharge matters reserved in outline permission, well, the original outline permission, as establishing consent for the line of the harbour edge now proposed in the current appeal proposal. However, that element of the 2009 permission extends out with the red line boundary of the outline planning permission and of the more recent planning permission in principle approved under appeal reference PPA-230-2340, extending the duration of the permission to 23rd June 2023. It would seem that the 2009 reserve matters approval cannot be relied on for repositioning the harbour wall, as there is no approval in the principle of development on that land from the parent outline permission. So the appellant's response to that is the previous owner of the site, Forth Ports, received outline planning permission on 23rd June 2003 for the Granton Harbour redevelopment defined by a red line boundary. On 4th of March 2009, the same applicant received reserve matters approval from the council for a master plan which included the additional area out with that red line boundary, which is the subject of this question. For this reason, the present appeal application was submitted as an application for full planning permission rather than AMC, as it covered a small area out with the 2003 outline planning permission boundary. The principle of developing that small area of land was approved by the council as part of the most recent master plan, Z7D, approved on 26 April 2001. So my question there for the appellant is, the master plan Z7D, or whatever the final letter we're looking at, is for approval of reserve matters, and I want to ask how that can establish the principle of development out with the area of the parent outline permission. Mr. O'Carroll.
I think the point being made by Mr. Payton there is that the present application acknowledges that, and that's the reason why it's an application in detail. That's as far as I understand it. If Mr. Payton has anything further to add, could I ask him to do that?
Yes, that's basically why the application was submitted in detail rather than, obviously, we could not have submitted an AMC application for an area out with the OPP boundary. I would add that I do say in principle, I mean, obviously the master plan that was approved in April this year showed that area of land as being developed. It showed the new key boundary. Now, while I appreciate that part that applied to that area didn't really have any status other than a council approval, the situation obviously is that we are now going ahead with an application in detail for the details of the infilling of that part of the harbour. But obviously the application we submitted was one for full planning permission, so it stands alone in effect, apart from the outline planning permission or the planning permission in principle.
Okay, thank you. Ms. Flood?
Thank you, sir. I don't think there's any disagreement with what the appellant has said there. The application in front of us today is a is a full application, outside the master plan, outside the outline planning permission. And I think we're all in agreement that the further details will be forthcoming in relation to the harbour wall and the infill of the land. So, that is forthcoming, and we understand that.
Good. Okay, so if we move then on to matter 5, again, I'll read out what was in the procedure notice. The Council's reasons for urging the imposition of proposed condition 6, that repositioning of the harbour wall to the east is not consented, are A, that repositioning of the harbour edge would be inconsistent with the then current master plan, 16, etc. AMC, though it subsequently acknowledges that the position is similar to that shown in master plan 06-03636 REM, and B, that part of the revetment along the harbour edge lies out with the original outline planning permission boundary. Since those reasons were given, the Council has approved another master plan, which is the 17, reference 17, etc. AMC, but with the exclusion of reserved matters for part or possibly all of plot 35A. This master plan reverts to the position of harbour edge shown in the 2009 master plan. How does that affect the Council's position? I have no questions from the Council's response. And then just turning then to the appellant at 5.1. While the response to this matter is directed at the Council, we would respectfully comment that the Council had approved the inner harbour alignment by its approval of the first Fourth Ports master plan, 4th of March 2009, again by its minded to grant the alignment of the present application on 17th March 2021, and then by its subsequent approval on 26 April 2021 of Master Plan Z7D. So I think probably looking at this question now, we've probably had all the answer to this, which is would it not be beyond the Council's legal powers to approve a harbour alignment through a reserved matters application where this went beyond the parent outline permission and at best indicate a sympathetic stance? I think probably we've heard the response to that now. Does anyone wish to add anything else?
Sir, if I may, if we're on matter 5, the matter has been canvassed in general terms through the previous matters raised by you, sir. There is one point I would like to raise, though, in relation to the answer to matter 5 by the local authority. And that there's something I have found again to be rather surprising, in that it's been raised now for the first time only in response to your question and did not appear in the committee report or the report of handling of 17th of March or at any time prior. And it's this part, it's the last big paragraph about halfway into it. It makes reference to condition 2. Then we're talking about details of rock revetment to be accompanied and to be provided and accompanied by wave modelling in this location. And then we've also got a reference there to assessment of potential environmental impacts. So I have to say that this is a perplexing answer to be included in the response to matter 5, since at no stage except until this very response to you has there ever been any detail sought on wave modelling or any other environmental impacts in relation to this application. And just to reiterate the point that is abundantly obvious, but I think I need to restate it, this is an application for the formation of roads, cycleways, footways in the public realm. So the allegation of a lack of information there, again, I think is safe to say, I would have to say, is without foundation. And that we have already discussed the other matters, and whereby these matters will be specifically detailed in the application to follow in relation to plot 35A.
Thank you. Ms. Flood, do you want to come back on that?
Thank you, sir. It's not intended to be an allegation, clearly, that information wasn't provided. It's simply a clarification on our side to say that, you know, we were not in a position to consent everything that appeared on the plan and the drawing without those details, and those details weren't part of the application. So it's basically a way of us clarifying that and saying that notwithstanding what's shown on the plan or the drawing, those elements are not consented. Those details will come forward in future applications, as we've heard, as we acknowledge. And that was really what our position was trying to express. And that's exactly why we've included those conditions, again, to clarify that those particular aspects of what's included on the plans and drawings are not consented. I'll ask Chris to say a bit more if he wants to.
No, thanks, Lottie. That's actually all I wanted to say.
Okay, thanks very much. Matter 6, looking at that, I have no questions to ask on the responses to this matter. I think we've covered the issues raised there. And so just without going over old ground, does anyone have any further comments in relation to that, for the responses to matter 6?
Sir, I have a response written down for myself, but it would be repeating what I said earlier, so I have nothing to add now. Thank you.
Okay, thank you. The same applies to matter 7. Again, does anyone have anything they wish to? Again, I think we've covered the ground already.
There is something I would like to add
Yeah.
in relation to matter 7, if I may.
Sure.
Again, it's a curiosity of the way in which things have been phrased here in relation to matter 7. I appreciate we've dealt.
Sorry, Mr. Carroll. Since we're streaming this and people might not understand what this is about, I better read matter 7 now if you want to comment on it. So I'll do that first. Sorry to interrupt you. The matter 7 is the Council's wish to exclude repositioning of the harbour edge from permission under current application based on an objection in principle to that line for the harbour edge, or a requirement for an application incorporating details of associated works or some other reason. If there is an objection in principle, how does the Council defend this, given that the first and most recent approved master plans show the same or a similar line for the harbour edge? So sorry.
It's really just a curiosity of the way in which things are said. But halfway through the answer, it says at the time considering application, the 20 application, an application for approval of reserve matters and conditions relating directly to the site in question was also pending consideration, and that is 17-0284 AMC. So that's the master plan application that we've been talking about that was granted in April of this year. The appellant was advised the Council did not have enough information to determine the acceptability or repositioning the harbour wall. I just find it curious that this has been written in such a way as to where in fact the local authority is fully aware of the reserve matters application, the application 02484 AMC having been granted at the time of which this was written, and sometime before the responses were provided to you in relation to this. I think you said the 7th of September. And again, the point being that there was no request for wave modelling or any other environmental impact reports in relation to that grant of permission. And to say that is simply clarifying something that wasn't applied for, well, you could equally well say there was no information given about the local corner shop or shopping centre to be located on site, and we could say that that was making it quite clear there was to be no such thing, because it hadn't been provided, because it wasn't part of the application. The point is that the local authority was dealing with a particular limited application before it, and the allegations or the statements made with regard to a lack of material being provided, it is not warranted in the circumstances.
Okay, thank you. Ms. Flood, any response to that?
Nothing detailed, sir, just simply to go back and note that there was never any intention to make any allegations or otherwise against the appellants on these matters. Thank you.
Okay, so that's the 7 matters looked at now. I said at the beginning that there would be an opportunity for a brief summing up by each party on this. Would you like a few minutes to put some thoughts together, or can we just proceed? Mr. O'Carroll.
I will. It's only 11:30, and if I could just take 10 minutes just to have a quick word with Mr. Payton, that would be very helpful.
Yeah.
But having said that, I'm not going to take it. I'm going to take over advantage, and I don't think I would be speaking for any more than about 5 or 10 minutes.
Fine. Good. Ms. Flood.
I'm happy to take that break. We can proceed now, but 10 minutes break is fine. Thank you.
Okay, fine. We'll take 10 minutes break. We'll call it 11 minutes just before that. We'll give you the full 10 minutes and a bit more. We'll resume at 11:15, 11:45. Thank you.
Hello, Morris. Hi. Did you try to call me earlier on, by the way? I'm already. Oh, sorry.
Okay, it's 11:45. Thank you. Are we expecting anyone else? Ah, yes, we are. I'll wait a moment. Fine. Okay, so I think we can resume. Thank you. Can I then invite Ms. Flood to make some summing up comments on behalf of the council, please?
Thank you, sir. I don't intend to say all that much in summary. I hope we've been able to provide some additional detail or clarity for you this morning on those particular matters. What I would say is I think it's apparent that there isn't very much distance between the parties on the specifics of this application. The council is satisfied with the substance of the application, satisfied with the principle of the development proposed within it. Conditions 5 and 6, we think, make it clear that notwithstanding what is shown on the plans and drawings submitted with the application, the proposed residential blocks and the repositioning of the harbour wall, they don't form part of the application or part of any permission, following thereon. And we do appear to be in agreement with the appellants on that point. We acknowledge that another application, for those details is forthcoming. That'll be considered, in the planning process in due course, as you would expect. As we recommended to the committee, we're very satisfied that planning permission could be granted here, subject to the conditions that we have included in the report and which we've alluded to in our response to this appeal. That's our position really, and I wouldn't intend to say anything much more. Thank you.
Thank you. Mr. O'Carroll.
I was actually just trying to note that down, but whilst looking at something on the page at the same time, did I understand Ms. Flood to be saying that the council is in agreement that this permission should be granted subject to the conditions that the council has sought already to impose? Was that what I heard? I wonder if you could confirm that for me, sir.
Yes, that's the position. Thank you.
Well, I think, sir, that really the question really then arises as to why it is that we're here. That we seem to have had a morning spent discussing matters, but in the event, the council seems to be quite clear for that the planning permission sought by the appellants should simply be granted. And really, it's a very, very unfortunate situation whereby they made that decision in March of this year and simply didn't issue the planning permission, which would be the normal course of events that would have followed from that decision. And here we all are spending quite a lot of time, resources, dealing with this matter now and taking up your time as well, so quite unnecessarily. In relation to the actual matters that have been discussed, there would appear to be almost unity then, if the appellants are saying that this appeal should be granted and the council is saying also it should be granted. However, that wasn't the flavour that was given with the responses that were given to the 7 points raised by you. I would, however, like to just address one specific matter because it's important in relation to what you yourself have raised. And it relates to matter 1, which I think is the area of greatest concern to you, sir. I might be so presumptuous to tell you what you're concerned with, but I presume it's number 1 for a reason. And you ask the question, can the development be consented in this form? Well, obviously, the answer from both the council and from the appellants is that yes, it can. You will have noticed on your site inspection that the area under the application is substantially completed, and my client, I'm told it's 75% completed. In terms of the original, in terms of the infrastructure that was installed by Forth Ports, the predecessor in title to the current appellants, 75% of the infrastructure is in place, and that then is a matter that you will be well aware of. But if you are feeling any disquiet with regard to being able to grant this appeal to allow the permissions sought, albeit against a non-determination by the local authority, and if this then still troubles you, sir, then it might be a solution, if you thought it appropriate, although I'm not saying it is, but if you thought it appropriate, it might be a solution to impose some form of a Grantian condition, which is of course lawful. So that if you felt that, albeit that the infrastructure is in place, and infrastructure dealing with the roads, cycle paths, and public realm is very substantially complete already in relation to this, and of course nobody's going to be walking on a wall revetment because they'll fall into the water. Then if you're not satisfied that there's enough in place for you simply to grant it, as both parties seem to be urging upon you, but that you require that there should be some other permission in place whereby those matters you consider outstanding, then it would be competent, although I say not necessary, but it would be competent for you to impose a condition to that effect. So it would be something, I'm not going to reword the permission for you, word the condition for you, obviously I wouldn't need to, but it'd be something along the lines of that the public realm roads and cycleways would not be implemented until further detailed approval in relation to rock revetment and infilling had been approved by the local planning authority. And that would simply get round the difficulty which I think you at least have outlined in your issue 1. So having said all of that, and the competency of that I think is clear, but having said all of that, it's not something I think is actually necessary for you. But that's as much as I wish to say. And as for the rest, with regards to the other matters, I think I've had the opportunity of expressing those in the course of this morning's discussion. So nothing further to add. Thank you. Unless.
Good. Thank you both. That's very helpful. Is there any? Are there any further matters parties wish to raise before we end?
Not that I'm aware of, sir. Unless Mr.
Okay, fine. So thank you all, everyone, very much for your contributions. I intend to issue my determination as soon as possible, and all the parties, including the third parties to the appeal, will be informed. So this hearing is now closed. Thank you very much.
Thank you, sir.
Thank you, sir.